My name is Christian Carson. I'm a probate attorney in Ohio, and today I'm going to go over with you probate alternatives. When don't you need probate in Ohio? So we've got a couple of alternatives here. First is certificate of transfer only. And I will say that all of these are situations that are specific to your facts and what you need to have done. Sometimes you don't have an alternative to probate. Sometimes you do need that full estate for whatever reason. That's why I try to go over this before we engage any client at all. We just try to figure out what the facts are and what really needs to be done. So first things first, certificate of transfer only. So this is when you have a piece of real estate and it's the only thing that you need to probate. And we're going to go to the probate court for this, but we call it a probate alternative because it isn't a full estate. It isn't that full-blown 6-month, 12-month process. This is just file it, the probate court signs it, and then you're done. So this is when we need to transfer real estate to heirs. So there could be a will or there could not be a will. This applies the same. So we just fill out this certificate of transfer, which is kind of like a deed that the probate court signs. And we file the application and we tell them who the next of kin is. If there's a will, we file it too. And then we pay them their $100 or whatever they want. And then they sign it and they send it back to us, and then we go record it. And once it's recorded, then the real estate is now transferred into the name of the heirs. So we're done. Second thing, relief from administration. This is only when you're under $35,000. So this is for small estates. And in some cases that can go up, like if there's a surviving spouse and the surviving spouse is getting everything, I think the level is $100,000. But in any case, $35,000 is the number to remember. So this is when we know exactly what assets we need to deal with. So let's say we've got an uncashed check for $34,999. Now we can use this. So we can go to the probate court. Again, we file one application called a relief from administration, and we attach a copy of the check and we say, here's what needs to happen, probate court. And then we fill out a judgment entry for them. We prepare it for the judge to sign, and then it becomes a court order if everything is in order. So that's a short way to get things done. If we know exactly what needs to happen and there's nothing that needs to be done other than just getting a court order saying you can cash this check. It also could be used for low value real estate. It mostly is used for cars and uncashed checks or maybe a small bank account, things of that nature. So these two are probate court activities that we do, processed by the probate court. These things are not. The affidavit for transfer of real estate inherited is something that a lawyer will prepare, and we prepare quite a few of these. This is a non-probate transfer of real estate. So it only works if the person died without a will. If they died with a will, we have to go through this. We have to do some kind of probate because, like I said in an earlier video, probate is Latin for proving a will. That's what it's for. We have to go through probate if we have a will. If we don't have a will, we can use this. So essentially, the affidavit for transfer of real estate states somebody died. Here is their next of kin. Maybe they've got 2 children and 3 children. We list them out. Maybe there's 2 children and a surviving spouse. We list them all out still. And then we then state what happens by the laws of descent and distribution in Ohio, what happens. So if they've got 2 kids and no spouse, then everything goes to the 2 kids in equal shares. So then it goes on to that affidavit. So we attach a death certificate to that. We go down to the recorder's office for the county that the real estate's in. We attach the description of the real estate. We file it. And then the county auditor will then transfer the real estate into the name of the heirs that we have put on that affidavit. Very simple process, doesn't take very long, but again, it's only available if there is no will. I should say that in the event that you want to sell the real estate after you do this, it's probably not going to be good if you're selling within the next 2 to 4 years. And the reason for that is that there is another statute out there that says that creditors can still make a claim if there's been no probate estate for 4 years. So some title companies will say, no, we don't like this, you need to go through probate. Others will not have any problem with it. So your mileage may vary. But I always ask anybody who comes to me and they say, we only have this piece of real estate we need to deal with. And I always ask them, do you plan to sell the house? If you plan to sell the house, tell them to do this. If they don't plan to sell the house, we can do this. And again, if there is no will. Last thing, now this is only going to be available if somebody has done this already before they die. This is transfer on death. So this is something we always have to check for every time somebody comes to us and they say we have to deal with this piece of real estate. So transfer on death is what this stands for. So this is something that anybody can do if they own a piece of real estate. They can designate a transfer on death beneficiary. And all it is a piece of paper that it's an affidavit. You sign it and it says, I want my real estate to go on death to such and such a person or multiple people. And then they go and they take it to the recorder's office and they record it. So this has to happen before death. It must be recorded before death, before we can do this. But this is a really widespread and popular form of estate planning. It's quick and dirty estate planning. It's really cheap, it's effective, and it transfers real estate directly without probate. So it happens a lot. And oftentimes I see people try to do probate on their own. They open an estate and then they realize 3 to 6 months later when they go to sell the house, there's a transfer on death already. Everything we did in the probate court's no good because we could have just filed an affidavit that just transferred the property already. And we didn't have to go through any of this nonsense. If there's a transfer on death designation affidavit on the record by the time somebody has passed away, then you actually can't do any of this. You can't open an estate. You can't do a certificate of transfer because this is the only thing that you can do is file an affidavit that confirms this transfer on death, and then the recorder's office will just transfer title. Very simple, very easy, but again, it's a pitfall. You gotta know what you're looking at. You gotta check the records before you go down any of these roads to make sure that there isn't one of these on the record. If there is, well, it could be wonderful because it'll save you a lot of time, but if there is, you don't want to go start doing any of these things. Anyway, so this is basically the 4 ways that we avoid probate. They have different uses and different use cases. So I hope that you've enjoyed this. Please check out my other videos. There's lots to learn about probate and estate planning.